everybody, welcome back to my YouTube channel. I'm super excited to have you watching this video. My name is Mary. I am a practicing lawyer in Nigeria. Also, I am a real estate consultant. On this channel, I share videos for laymen and also for lawyers. If this is your first time of seeing my beautiful face, please do not forget to click on the subscribe button. And if you're a returning subscriber, thank you for always coming back to watch my videos. In today's video, I'll be explaining how to lead your witness in examination in chief. This video will be more useful for lawyers in Nigeria and also in other jurisdictions because I believe this particular aspect of practice is actually sort of the same with other countries. So we have examination in chief, we have cross examination, and we also have re-examination, which are the core aspects of litigation in Nigeria. So let's talk about it. What is examination in chief? This is the opportunity that you have as a plaintiff or a defendant to actually prove to the court, to bring a witness to the court, to actually produce some documents in order to establish your claim. As a counsel, it is important for you to coach your witness before the hearing date, and also for you to learn the acts of examination in chief. Okay, so we have a civil aspect, we have criminal aspect. It's actually the same thing. Yeah, it is the same thing. However, in civil suits, you see us filing list of witnesses and a statement on oath. So in that situation whereby you have your evidence, the witness evidence already before the court, all you need to do on that day is to make your witness adopt the statement on oath, also to lay foundation in tendering the document that will help you to establish your case. So that is it. However, in criminal cases, we do not file list of witnesses and statements on oath. So what it actually means is that in civil cases, oftentimes, even in the magistrate court, you see some magistrates saying, counsel, can you please put it in black and white? Your statement, witness statement, can it be documented before the court and all of that. So in the situation whereby that is being filed, the person will adopt, the witness will adopt. I will explain how to adopt and all of that. So the witness will adopt, and also you will lay foundation on how tendering the documents. However, in a criminal case, the person will actually have to explain everything that transpired. Okay, so that is the difference. In some situation, in civil cases, you don't file that, and which means your witness will have to explain everything that transpired. Okay, so let's just do it in full as if it is a criminal case now. Okay, so I'll be sharing the do's and don'ts of examination in chief. Do's and don'ts of examination in chief. Number one is, in examination in chief, you don't ask leading questions. Leading questions are actually questions that suggest the answer. If you had to ask, for example, we're in the courtroom and I want to ask my witness a question like, the date of the incident is actually the 1st October 2020, right? Definitely, I'm already suggesting to my witness definitely answer in affirmative. Okay, so you can actually, if you're watching me and you find yourself in that kind of a situation, you can actually object to that is a leading question, and the judge will definitely tell the counsel to rephrase the question. Okay, so you don't ask leading question in examination in chief. And it's so important that your witness is not coming to court to come and give hearsay evidence. Generally, hearsay is inadmissible in law. So do not bring somebody to the courtroom to come and give evidence on what he did not experience, what he was being told. Okay, so that will definitely not hold what. Another don't is, do not ask irrelevant question. If that question or the answer would definitely not help your case, there's no point in you asking it. And I do see lots of lawyers doing that, especially my early years of practice. I will see people asking questions, I'll be lost. Like me as a young lawyer, I'll even be thinking like, what does that question has to do with the subject matter? So no hearsay evidence, no leading questions, and don't ask irrelevant questions. So those are the don'ts. Let's talk about the do's. One thing, the first thing that is important is make your witness comfortable. Okay, about 2 weeks ago, I was in court, and the other side, the prosecutor, actually invited an elderly man, and I could see. I actually wanted to suggest it, but I just didn't do that. So the judge herself was even the one that asked, okay, this is an elderly man, can we please get a chair for the person? So if you have a witness who's an elderly person, or probably the person is having some health challenges, so it is important for you to make that person comfortable, because there are some counsel, they know how to actually shake a witness. Like the witness can be dumbfounded. So it's important that that person is having the right posture. If the elderly person make a request for a seat. Okay, so make your witness comfortable. Number 2 is please always ask open-ended questions. Open-ended questions are questions that make the witness to answer, to give a longer response, okay, such as what happened there, when did it happen, why. So the person will be able to give lots of explanation and reasons, okay. So do not forget, in civil cases, if you do not file your statement of oath, that is when you'll be asking when did that happen, what did that happen, and all of that. But if you have filed your witness statement of oath, you don't need to waste the time of the court. All you need to do is to adopt by telling the your witness, did you remember filing a statement of oath at so place at so time? The person will definitely answer yes, okay. So, and you ask where is the, sometimes counsel do that, where is the registry. Your witness can point downstairs or somewhere, just to know, just to make it known to the court that your witness actually came to the courtroom to sign as a deponent. After asking those questions, you ask your witness, what do you want this court to do for you? And that is when the person will say, I want the court to do that, and all of that. So then you can now talk about, you mentioned in paragraph 6 of your statement on oath that there are certain documents, a tenancy agreement. If you see the tenancy agreement, we'll be able to identify it. Your witness will say yes, okay. How will you identify it? By the dates, or my signature, or my passport photograph. You will tender from the back, you will you apply to the court that the document should be shown to the witness, and the court registrar or the clerk will take the documents to the witness box, sorry. And if the witness identifies same as being the document, then you can apply. If it's a photocopy, if it's a secondary evidence, you lay foundation as to where the primary document is, okay. And this is a photocopy. Where is the original copy? It is not with me, I lost it, or something happened to it, it is with someone, and all of that. So you have laid foundation. So by so doing, the other counsel will check if he or she have any objection. So that is me making a short explanation about you laying foundation for the documents, and also making your witness to adopt the statement on oath. But in a situation whereby, I actually jumped a lot of things, but you get it in this other part that I'm about to explain, okay. So let's just talk about it like in a situation whereby there is no witness statement on oath, like a criminal case. So the first thing is, once a case is being called, you announce your appearance, you sit, the other counsel will announce his or her appearance, and the person will also take a bow and sit. And then you tell the court the business of the day. My lord, this matter is stated for hearing, and subject to the convenience of the court, we are ready to proceed. After informing the courts of the business of the day, if the court is ready to proceed, and if the other party does not have any objection as relating to commencing hearing, you then call your witness. You mention the name of your witness, and the clerk will say something like, if there are other witnesses in the courtroom who want to testify in that case, those people should vacate the court premises, the courtroom. To vacate the courtroom and all of that. So your witness will be sworn on oath, and at this stage you will start asking questions. Please make sure you ask one question at a time. The elementary question are, what is your name, what do you do for a living, and where you reside. So you see a lot of people lumping these 3 questions, asking it at once, like witness, can you tell the court your name, what you do, and where you reside? No, take the question one step at a time, okay. So let us now have a witness in the witness box, and his name is Mr. Williams, okay. So I will have I may not necessarily call his name, okay. So I can just say, witness, can you please tell this honorable court your name? I am Williams Ariwo Shela. Where do you reside? He will say it. What do you do? He will say it. And he asks, take a look at the defendant in the witness box. Do you know him? You will say yes. How do you know him? The 4th question will be, who is he? And he will say, he's my friend, we had a business, whatsoever that might have transpired, or how they got to know each other. I will say that. So after those 4 questions or 5 questions, your name, the witness name, where the witness what the witness do, and whether the witness know the defendant, and who the defendant is to him. So after those 5 questions, other questions can now be open-ended questions. This is examination in chief. So open-ended questions are the best type of question you can ask a witness in order to make the witness to give a longer response just provided that those response will be relevant to your case. And you know, someone in the witness box, they will definitely not know when to stop, except if you have truly coach that witness before commencing hearing. But in a situation where you see that the witness is deviating into some irrelevant issues, oftentimes you see the judge not writing anymore. But so please just pick the ins and tell the witness, can you just explain what transpired on so dates that I've earlier mentioned? All these other facts are not necessary. Okay, so you do that. And when asking those open-ended questions, it is possible that your witness may say certain things that are not clear, so you can actually say, what do you mean by saying that? Your witness may be talking and saying, and the parties actually entered the agreement. You can ask, who are the parties in particular? You can now say the defendant and so person. Okay, so you can always interrupt, but do not interrupt when you know he's saying something that is very, very correct or something that is relevant, because your witness can actually lose this train of thought. Okay, so make sure anytime you want to interrupt, it is when he's saying something that is irrelevant. If you have a question while he's saying something that is relevant, it is necessary that you note it and not to interrupt him at that moment, in order not to lose his train of thought. This other part I want to talk about is now laying foundation. Okay, laying foundation for your witness to tender documents. So after there's lots of explanation, I said it earlier that it is important for you to quote your witness. So while explaining, you must have mentioned some documents. Okay, if you did not quote your witness well and you forgot to actually mention those documents, it will be difficult for you to tender those documents, lay foundation and tender those documents. Okay, because the court will now be wondering, where did the documents emanated from? So it is important that, okay, myself and defendant is my landlord, and we entered the tenancy agreement. Tenancy agreement has actually, he has mentioned it. So you can then ask, okay, thank you witness, after the whole explanation, you talked about, Mr. Williams, why giving your evidence? You mentioned a tenancy agreement. If you see the said tenancy agreement, will you be able to identify it? We will say yes. How will you identify it? Please make sure that you check the courts. If the court is writing, make your questions slow. Okay, don't be in a hurry in order for the court to capture everything. It is not in all courts that they record proceedings. Okay, so and when your witness is also talking, make sure you quote your witness in order to take it slow. Make sure you give the hint to your witness as well in order to take what he's saying slowly in order for the court to capture everything. Okay, so you mentioned the tenancy agreement. If you see the said tenancy agreement, will you be able to identify it? It will say yes. How will you identify it? By my signature and maybe my name and all of that. If you say that, you will apply to the court. I've mentioned that earlier, but I actually did that in a hurry. So apply to the court that the clerk of the court should take the documents to the man in the dock, in the witness box. So you will check and you will answer an affirmative, and you will ask, where is the original? If it's original, you're good to go. But if it's a photocopy, it is important for you to lay a foundation. If not, the other counsel will object it. Okay, so this tenancy agreement is a photocopy. Where is the original? You may say the original is with my wife, and my wife is not in the state, or I lost the original and this is a photocopy that we have, and all of that. So you ask him, what do you want the court to do with these documents? You want the court to adopt it, you want the court to accept it as part of my evidence and all of that. So the clerk will take the documents to the other counsel, and the counsel will check. If there is no objection, you apply to the court that the documents be admitted as exhibits. So it is possible that the judge say, counsel, can you please identify all of the documents and tender them all at once in order not to waste the time of the court. So you say probably if the witness actually adopted a written statement on oath. So you mention the paragraph, my lord, in paragraph 7 the witness mentioned a tenancy agreement, in paragraph 10 the witness mentioned a confidentiality agreement and all of that. But if there is nothing like a statement on oath, you talk about it like, okay, here are the documents, you will mention them all, and you will apply to show all the documents to the witness at once. And if the photocopies are mentioned earlier, you made mention of laying the foundation for where the original are. And if any of those documents is a computer generated evidence, you also lay foundation as relating to the certificate of compliance. Although there is actually a Supreme Court authority, the Supreme Court of Appeal, actually said it's not necessary for you to provide certificates of compliance as relating to section 84, that it is possible that the person who actually printed those documents can actually come to court to give an oral evidence as relating to that. So just lay a foundation as to whether they are originals or photocopies, or if they're computer generated evidence, and apply that. All will be shown to the other counsel, and you apply. If there's no objection, you apply to the court that it should all be admitted as exhibits. And that is that about examination in chief. When you're done, you say that is all for the witness, my lord, and the other counsel will have the opportunity to do the examination in chief. If evidence is being completed on that particular day, your witness will be discharged. If you could not complete evidence on that day, probably you have to adjourn for cross-examination. The witness will step down. The different application you make to the court. My lord, may I apply that the witness may step down? That is if you will have to come back to give more evidence. You are here to conclude that with that particular witness. If you're done, you say, my lord, may I kindly apply that the witness may be discharged, and the court will say the witness can actually leave the witness box. Okay, so that is that basically about examination in chief. If you have any question, please do not forget to just drop a comment in the comment section, or you send it via my email address. My email address will be in the description box. Thank you so much. Don't forget to like this video, comment and share. I will see you in another video.